Hello viewers, welcome to my channel. I'm Hasham. So in this video I'm continuing the last session, that is Sale of Goods Act 1930. Last two videos I have explained you about the contract of sale. What do you mean by contract of sale of goods, and what are the essential elements of a valid sale. These two topics I have discussed in the first video. Second video I have explained you about the differences between sales and agreement to sell, and what are goods and what are the different types of goods. These are the things already I have discussed in the last two videos. So if you have not watched those videos, I suggest you to go to the playlist of my channel, select the subject business law, select the videos of sale of goods, watch the first video, be acquainted with the main meaning of the term sale of goods and what are the essential elements. Now in this video I am going to explain you about very important topic, that is conditions and warranties. The meaning of conditions and warranties. What are the differences between conditions and warranties, and what are the implied conditions and warranties. So these three topics I am going to discuss in this video, and remember this topic is very important from examination point of view. Every now and then they will ask a question regarding conditions and warranties. So listen and watch carefully. Conditions and warranties. So when a contract of sale of good is made between buyer and seller, they agree upon certain terms and conditions. So wherever there is a contract of sale between a buyer and a seller, there will be some terms and conditions regarding the subject matter of the sale agreement. Subject matter of the sale agreement. Example, A and B are the buyer and seller for a car. A wants to sell, B wants to buy the car. So car is the subject matter. When A is selling the car, B is buying the car, there may be some terms and conditions. There may be some representations made by the seller. The seller will say something about the car. Some terms and conditions, some representations will be given by the seller to the buyer. So these representations made in a contract of sale by the seller to the buyer are called stipulations. So stipulations are the representations made by the seller to the buyer at the time of making a contract of sale, and those representations are called stipulations. Now we can divide the stipulations into two categories: important stipulations and less important stipulations. The very important stipulations made by the seller to the buyer regarding the subject matter of the contract are called conditions. Conditions are the very important representations, very important stipulations made by the seller to the buyer at the time of making the contract. And the less important representations or less important stipulations made by the seller to the buyer are called warranties. So very important stipulations are conditions, less important stipulations are warranties. What are stipulations? Representations made by the seller to the buyer at the time of making the contract regarding the subject matter of the contract. So conditions and warranties. So here I have given you, they are known as stipulations as per the law. Some of them will be very important and others are not so important. So when stipulations are made by the seller, some stipulations are very important, more important, some are less important. The most important stipulations are called conditions, and the less important stipulations are called warranties. Now I think your concept is clear regarding conditions and warranties. In specific words I will say, conditions are those stipulations. Conditions are those stipulations which are given by the seller to the buyer regarding the subject matter of the contract, which are very important. The very important stipulations given by the seller to the buyer are called conditions. And the less important stipulations made by the seller to the buyer are called warranties. So the seller should satisfy all the conditions, without fail, otherwise the buyer will repudiate or reject the contract. That means whatever conditions are there, what are important representations are there, completely representation should be given by the seller to the buyer. That means car is there, I am the seller of the car and you are the buyer. So at the time of selling the car, I should disclose whatever are the facts of the car. Whatever are the facts of the car. If I do not disclose all the stipulations about the car to the buyer, then later on buyer will reject the contract, will repudiate the contract, he will not buy the, and he can claim damages from me because I have not explained the full fact. So here the seller must disclose all the conditions, must explain all the conditions about the subject matter. Otherwise the buyer will repudiate the contract, reject the contract. But if the seller fails to satisfy warranties, the buyer cannot repudiate the contract. The seller should be allowed to perform the contract, paying a reasonable damages for the breach of warranty. Now see here, seriousness. Conditions are very serious. If there is a breach of condition, buyer will repudiate the contract, reject the contract. He will return back the goods to the seller. If there is a breach of condition, suppose if there is a breach of warranty, then the buyer cannot repudiate the contract. The buyer can claim damages from the seller because these stipulations are not so important. Important stipulations are conditions. Less important stipulations are warranties. So the violation or breach of warranty will not repudiate the contract. The buyer can claim damages. Whereas breach of condition, then the buyer can repudiate the contract. That is the difference. Now, breach of condition can be treated as breach of warranty, but breach of warranty can never be considered as breach of condition. Suppose if the seller has made the breach of condition, the buyer can treat it as breach of warranty. For example, A has made a breach of condition to B. B is the buyer. Now B can repudiate the contract. B can repudiate the contract, but B is not repudiating. B is asking A, I am accepting the car. I have the right to return back the car, but I am not returning. But I will claim for damages. I will claim for damages. That means he is treating breach of condition as breach of warranty. But breach of warranty can never be considered as breach of condition. Warranty will never become condition. Condition may become warranty. So this is the complete explanation regarding conditions and warranties. Conditions are the main stipulations given by the seller to the buyer. The breach of which will give a right to the buyer to repudiate the contract. The breach of which will give the right to the buyer to repudiate the contract. Whereas warranties are not essential but collateral or supplementary stipulations. Supplementary stipulations given by the seller to the buyer. The breach of warranty will not give the right to repudiate the contract, but the buyer can claim damages for breach of warranty. Or very important stipulations are called conditions and less important stipulations are called warranty. The stipulations are the representations or terms and conditions in a contract of sale. That's all. So this is the complete explanation about conditions and warranty. Another question may be asked in examination: what are the differences between conditions and warranties? Yes, few differences are there. Both are stipulations. Both are the stipulations made by the seller to the buyer at the time of entering into contract of sale. But what are the differences? First difference, they are very important stipulations. They are less important stipulations. So when we see the seriousness, importance, we can say conditions are very, very important. The seller must disclose all the conditions to the buyer. That's why it is very important. Whereas warranties are not so important, they are supplementary, they are collateral stipulations. Then second one, they go into the root of the contract. That means the complete contract will be shaken by the breach of condition. The contract will be finished when there is a breach of condition. So the conditions will go to the root of the contract. Whereas in this case, warranties, they do not go to the root of the contract. It will not completely shake the contract, only damages can be claimed if there is breach of warranty. Contract of sale can be repudiated on the breach of condition. Repudiated means rejected, terminated. The contract of sale will be terminated, repudiated if there is a breach of condition. Condition is broken, then the contract can be repudiated. But in case of warranty, if there is a breach of warranty, the buyer can claim damages. The buyer cannot repudiate the contract. The buyer cannot repudiate the contract. He can only claim damages. Next one is, a breach of condition can be liberally viewed as a breach of warranty. So liberally, we can convert a breach of condition into breach of warranty. I am the buyer. When the seller has made a breach of condition, I can repudiate the contract. I can reject the contract, but it is in my hands. It is at my option. I will not return the contract. I will simply ask the seller, I am having the right to return, but I am not returning. I will only claim damages. So here condition is treated as a warranty. But warranty can never be converted, cannot be treated as a condition. When there is a breach of warranty, we cannot treat it as a breach of condition. These are the differences. So in examination, very frequently they will ask, what do you mean by conditions and warranties? What are the differences between conditions and warranties? Now, types of conditions and warranties. There are two types of conditions and warranties: express conditions and warranties, implied conditions and warranties. Two types of conditions and warranties. So first of all, we'll discuss about express conditions and warranties. Express conditions or warranties are those terms and conditions which are expressly given by the seller to the buyer, either by a word of mouth spoken or in written. That means the stipulations are either spoken or written expressly by the seller to the buyer. By the seller to the buyer. Example, I am the seller, you are the buyer, I am selling my car. At the time of selling my car, I disclosed the important facts of the car. The important facts of the car I am expressing you. I am saying to you either through a word of mouth or in writing. It is called express conditions and warranties, which are specifically given by the seller to the buyer, either by word spoken or written. Implied conditions. The implied conditions and warranties are those conditions and warranties which are not expressed, but which are applied by the law, by the Sale of Goods Act 1930. The Sale of Goods Act has given some implied conditions and warranties. So those conditions and warranties which are not expressed, but it is given by the law, implemented by the law, are called implied conditions and warranties. Now, now I am going to explain you about implied conditions. In examination, they have asked, what are the implied conditions in a contract of sale? So here I am going to explain you. The Indian Sale of Goods Act 1930 has given a number of implied conditions in a contract of sale. The first implied condition is condition as to title. Condition as to title. According to this implied condition, the law says whenever a person is selling something, we should assume that the seller is having the title of the goods, because only the owner can sell the goods. Only the owner of a thing can sell the goods. So in other words, we can say whoever is seller, we can assume that he is the owner. He is the owner of the goods, right? So Condition as to title means in a contract of sale, we can assume that the seller is having the right to sell. When he is having the right to sell, he is having the title. He is having the title of those goods, of that goods. For example, a person is selling the car. I want to purchase it. When the person says, it is my car, I want to sell it. I am selling it. So what I can assume? That he is the owner of the car. He is having the title of the car. That's why he is selling. If he does not have the title, how he can be able to sell the goods, sell the car? He cannot be able to. Only he is selling because he is having the title. So there is an implied condition on the part of the seller that in case of sale, the seller has a right to sell the goods. And in the case of agreement to sell, he will have the right to sell at the time when the sale is to be made. At the time, later time. That means whenever there is a contract of sale, it is understood that the seller is having the right to sell in case of sale. And in case of agreement to sell, the seller will have a right to sell at a later date. That is the first implied condition. Condition as to title. Second, sale of goods by description. Sometimes goods are sold according to the description given by the buyer. Suppose I am the buyer. I will go to the seller and say that I want this type of goods. I want this type of goods. I have given the complete description of the goods. It is called sale by description. That means the seller is selling the goods according to the description given by the buyer. In that case, what is the implied condition? The implied condition is the seller should sell that goods only which are described by the buyer. That means the goods should correspond with the description. The seller should sell only that goods which are described by the buyer. That is the implied condition as to description. When the goods are sold by description, there is an implied condition that the goods shall be similar to those described. That means goods should be according to the description. Then third, sale by sample as well as description. Sometimes goods will be sold according to sample. The seller is giving some sample to the buyer and saying that the goods which I am selling are according to this sample. In that case, when goods are sold by sample, there is an implied condition that the bulk of the goods should correspond with the sample. There should not be any difference between the sampled goods and the bulk goods. The bulk and sample both should be same when the goods are sold by sample. If the goods are sold by sample and description, both are there, then in that case the law says the goods should correspond not only to sample but also to the description if the goods are sold by both sample as well as description. Here, condition as to quality and fitness. Quality of the goods and fitness. There is no implied condition regarding the quality and fitness or suitability of the goods. Here, one term plays that caveat emptor. One Latin word is the caveat emptor. The meaning of caveat emptor is let the buyer beware. When the buyer is purchasing some goods, the seller does not know for what purpose he is buying. So buyer should be clear in his mind regarding what type of goods I require, which type of goods will be suitable for my purpose. So there is no implied condition as to the quality or fitness of the goods. The buyer should decide himself. The buyer should decide himself regarding which quality is which type of goods are suitable for my purpose. So here there is no implied condition as to the quality or fitness of any particular purpose of goods supplied under the contract of sale. In other words, the buyer must satisfy himself about the quality as well as suitability of the goods. So it is not the responsibility of the seller, it is the responsibility of the buyer to decide what type of goods I require for my purpose. Next, condition as to mercantability. mercantability. The goods sold in the market should be free from manufacturing defects. See, when goods are sold by the seller, it should serve the purpose of the buyer. Example, a person will purchase a refrigerator to keep all the household items cool, to make cold drinking water. So, for the purpose of cooling the goods, he has purchased a refrigerator. So, it is the responsibility of the seller to provide that refrigerator which makes cooling. Similarly, in AC, air conditioner is purchased. Why a person will purchase air conditioner? To make the room cooler, to make the complete room cool, he is purchasing. So, the seller of air conditioner must sell only that air conditioner which should cool the room. That means mercantability means the goods should be free from any manufacturing defect. There should not be any manufacturing defect in the products. So therefore, if the seller supplied goods without verifying the mercantability of goods, he becomes liable for quality. If he sells a good which is not mercantable, which does not have manufacturing quality, then definitely he will be liable. Next one is condition as to wholesomeness. This implied condition will apply normally for food items which are consumed by human being. Food items. So, in case of eatables and other food stuff material, there is an implied condition as to the wholesomeness. There should not be any mixing. It should not be any adulterated. The goods should not be adulterated. The goods should be wholesome because it is consumed by the human being. It is consumed by the human being. That means it means goods should be fit for human consumption. The goods which are supplied by the seller should be fit for the human consumption. The human being is consuming it. It should not be adulterated. It should be genuine. Then otherwise the goods can not only be returned but also damages can be claimed. If the seller has not supplied wholesome goods, then what will happen? The contract will be repudiated. The buyer will return the goods. Not only the buyer will return the goods, but also the buyer can claim damages from the seller because the goods are not wholesome. So these are some of the implied conditions in a contract of sale, and these implied conditions are given by the Sale of Goods Act 1930. Come on, now we will discuss the implied warranties. Just now we have seen the implied conditions. These implied conditions and warranties are those conditions and warranties which are given by the Sale of Goods Act, which are not expressly given by the seller to the buyer. So implied conditions already we have seen. Now I am explaining you about implied warranties. The main difference between conditions and warranties: if there is a breach of condition, the contract can be repudiated, rejected. Whereas in case of breach of warranty, only damages can be claimed. The contract cannot be repudiated. That is the main difference. Now what are the implied? In other words, we can say conditions are very serious one in the contract of sale, whereas warranties are not so serious. Now, implied warranties. The first implied warranty in a contract of sale is warranty regarding quiet possession. When the buyer has purchased the goods, when the buyer has bought the goods from the seller, he should enjoy quiet possession of the goods. His possession should not be disturbed by the seller. Suppose if I am the seller, you are the buyer, I sold my car to you. Now you are having full liberty to use the car. I should not interfere in the usage of car. Once I sold the car to you, you should be free. There you should not get disturbance from the seller. So when goods are sold away, the seller should not cause any type of disturbance to the buyer. Once I sold the car to you, I should move away from your using the car. How you are to use the car, it's you have to take. Otherwise, it becomes a breach of warranty. If I make any disturbance in the usage, then definitely I'll be prosecuted for breach of warranty. The buyer should be allowed to enjoy undisturbed possession of goods. That is the first implied warranty, quiet possession. Once the goods are sold by the seller to the buyer should have quiet possession. The possession should not be disturbed. That is the first. Next one, free from encumbrances. Encumbrances means charge. Sometimes the goods are under a charge like pledge, hypothecation, etc. Goods sold under a contract of sale should not have any charge like hypothecation, charge or pledge on them. Otherwise, it becomes a breach of warranty. If there is a charge on the goods sold, for example, Mr. A sold a car to Mr. B. Already it is hypothecated one. But by not showing that the car is hypothecated, he has sold the car to B. B has purchased it. Later on, he come to know there is a hypothecation. Now, there is an implied warranty that the Mr. B can claim damages from Mr. A. Damages from A, and ask the seller to clear the hypothecation, to make the payment to the hypothecator. So here, otherwise it becomes a breach of warranty. The seller becomes liable to discharge the charges or pledge, if any. Whatever pledge, hypothecation charges are there, he has to clear off and then give it to the buyer. Then implied warranty regarding sale of dangerous goods. Some goods are dangerous, like crackers are there, some works are there. So some dangerous items are there. What is the implied warranty in case of dangerous goods? So as per the provisions of the Sale of Goods Act in the contract of sale, goods should be safe to the buyer. Goods should be safe to the buyer. The packing and all these precautions should be taken by the seller. It should not be dangerous to the buyer. Suppose if the buyer incurs a loss, whether physical loss or monetary loss, then that loss should be borne by the seller, because he has to take all precautionary measures when he is selling the dangerous goods. If he has not taken any precautionary measure, and if there is a loss incurred by the buyer, then the buyer can sue the seller for damages. Next one, implied warranty annexed by trade customs or usage. Sometimes the goods are sold according to some usage, according to some trade, customs, etc. In that case, what is the warranty, implied warranty on the part of the seller? When goods are sold by auction, goods are sold by bidding, the auction or in open market, then the defects of goods known to the seller should be disclosed to the buyer. So if the defects of the goods are known to the seller, then definitely it is the responsibility of the seller to disclose that facts to the buyer. Whatever defects he knows, the defects should be disclosed to the buyer so that he can take preventive measures. Otherwise, the seller becomes liable for breach of warranty. If the seller has not disclosed the defects in that goods sold, ultimately the buyer has incurred some loss. So buyer can claim damages from the seller. Normally this will happen in case of example drugs and medicine manufacturers. The medicine and drug manufacturers will write the expiry date. So whenever we purchase the medicine, we first of all see the expiry date, whether it is expired or still we can be able to use it. So these are the implied warranty annexed to trade, customs or usage. So 4 implied warranties I have explained, some 6 implied conditions I have explained. In examination, you may be asked a question regarding what are conditions and warranties. What are the differences between conditions and warranties? What are the types of conditions and warranties? Expressed conditions and warranties and implied conditions and warranties. The implied conditions or warranties are those conditions or warranties which are given by the Sale of Goods Act. And express conditions and warranties are those which are expressly given by the seller at the time of making the sale contract, either by word of mouth or in writing. Expressly he has given all the terms and conditions. That is called expressed. Implied conditions and warranties are given by law. So we have seen what are the implied conditions, what are the implied warranties. That's all. So this is the end of the topic, conditions and warranties. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, we'll continue the next topic in this Sale of Goods Act in the next video.